Hey, everybody. Oh, I look weird. I have the window open and it's all shiny. Anyway, hello, Sushi Crew. I have some news for you. I have the prosecution's response to Mark Bean's filing from when Lori Vallow allegedly spoke with Daniel McConkey. And I want to share that with you right now. I just got home, so I thought I'd do that real quick. If anybody saw me talking about ADD and Amazon and my little coping mechanisms for that, I talked how I used an Amazon Echo or an Amazon Alexa, whatever, to help me with those things. And they are on sale Black Friday. So go check that. I think they're like $20. I don't get anything from that. I'm just telling you because, you know, if it's something you're interested in, $20. Pay that for a cock radio at the drugstore. So anyway, just thought I'd let you know. So I'm going to go ahead and share my screen. Let's see here. I already have it up. That's why. Do that real quick. Before we get started, I'll tell you this. A little backstory on this for people that are playing catch up. Mark Beans went to go have a meeting with Lori Vallow, and Lori told him that the clinician supervising her had, as part of her homework, advised her to call another attorney and gave her the number for the attorney for the LDS church. And that would be Curtin McConkey. So allegedly she did. And she spoke with Daniel McConkey. And Mark Beans was very upset because he doesn't know exactly what they discussed. And Curtin McConkey called the prosecution to report the phone call. And he, meaning Mark Beans, wants to know the content of this phone call. He objects to a lot of what happened. And he submitted a filing asking for a lot of things to be turned over, all the phone conversations, any text messages, any emails, anything like that, clinician records, the like. So I will say it was very poorly written. It was very loosely written, and you'll see why I say that when I read the response to you. So if you give me 1 second here, I'm going to flip over so I can see a little bit better. And I made it pretty big so that you guys can see. So this was filed on, oops, are we going to do this the whole time? Let's not do this the whole time. Let's just not. Okay, all the way up to the top. So this was filed on November 24th. You know me and date, so let's just look at what day that was. Give me a second here. You guys, I was just looking at the calendar. I'm like, there's no November. That's not true. So it was the Wednesday before Thanksgiving. So day before Thanksgiving, this was filed on behalf of Lindsay Blake and Rob Wood, Office of Fremont County Prosecution, State of Idaho versus Lori Noreen Vallow, a.k.a. Lori Noreen Daybell. Let's make it France. Daybell. Response to declared motions regarding motion for state to disclose Brady violations disclosures, motion for criminal depositions, motion for out-of-state subpoenas, and motion to disqualify Idaho Department of Health and Welfare. Okay. Well, that was nice. Hold on 1 second here. Okay. So this is 9 pages. When we get to like statutes and numbers and things like that, I will spare you that. And I will post these on True Crime Sushi on Facebook. I will put a link to them on Twitter. And I will try to drop a link to them on the community page because I can't post that many pages at a time, unfortunately. So get with the times, people. There's a lot of stuff we want to post. All right. The state of Idaho hereby responds and objects to defense counsel Mark Means' declared motions regarding 1. Motion for state to disclose Brady violations disclosures. 2, motion for criminal depositions. 3, motion for out-of-state subpoenas. And 4, motion to disqualify Idaho Department of Health and Welfare hereinafter declared motion. The state's response is based on the following grounds and argument. And then they put one little footnote here. While it is customary to refer to the defendant and their attorney as the defense, it would be inappropriate in this response to do so. The defendant, Lori Vallow Daybell, is currently deemed incompetent, and a stay exists in her case. She is also co-represented by death penalty qualified counsel Jim Archibald. It is of note that Mr. Archibald did not sign this filing, and it appears that Mr. Means acted unilaterally in preparing and filing this motion. There is no affidavit from Lori Vallow Daybell supporting such allegations. Where the defendant is deemed incompetent and cannot consent to such a filing, where the defendant has made no verified assertions to support such motion, and where Mr. Archibald did not sign said motion, it is appropriate to consider this Mr. Means's filing for clarity rather than as an actual filing of the entire defense team. And that's interesting because we did notice and discuss when Mark Means filed this that Jim Archibald did not sign off. We talked about having t-shirts saying, where's Jim Archibald? I can't imagine that he was pleased that this was done. I don't know how Mark Means became such a loose cannon in this case. And I will say after reading, or before I even read this to you, I will say in my personal opinion, not only is this embarrassing to Mark Means and the defense as a whole, because it is, I think it could also be used to further prove the point that Mark Means is not qualified to represent Lori Vallow in any capacity or Lori Daybell in any capacity. He is a poor excuse for an attorney. He takes shortcuts. He had a good outline going, but when you're asking for things, when you're filing a motion, you have to be extremely specific about what you're looking for. You can't just, or what you're asking for, not looking, asking. And sometimes you have to do your own footwork too. People just don't hand you things. So there seems to be a clear disconnect between Mark Means and what he should have learned in law school. But I'll show you. Okay, so number 1, the declared motion for the state to disclose Brady violation disclosures mischaracterizes the law, the state's facts, and other communications, and fundamentally is not supported by law or fact. It goes on to say, Brady material is material or evidence in the possession of the state that is potentially exculpatory or tends to negate the guilt of a person charged with a crime. The concept of Brady material derives from the United States Supreme Court case Brady versus Maryland. There's all the numbers. It's 1963. In Brady versus Maryland, the United States Supreme Court held that the suppression by the prosecution of evidence favorable to an accused upon request violates due process where the evidence is material, either guilt or to punishment, irrespective of the good faith or bad faith of the prosecution. Brady holds that prosecutors must disclose Brady material. The declared motion requests the state be required to turn over Brady violation disclosures regarding the comments made by Lori Vallow Daybell to Daniel McConkey, an attorney at Curtin McConkey. This request is misplaced. Here we go. The declared motion appears to create the label Brady violation disclosure or so named item. Yet, the motion fails to define the item and to supply a legal basis for such a legal categorization. So, Mark Means is asking for Brady violation disclosure, but he fails to ask what he's asking it for, like what specific instance, I guess. and filing a legal basis, which is basic. The state is left to surmise or speculate that the declared motion's intent was to argue statements made by the defendant, Lori Vallow Daybell, to an attorney not associated with the case or the prosecution, are somehow Brady violation disclosures. There is no authority for such an argument or legal conclusion. Statements of Lori Vallow Daybell to a third party are not associated with the state, are not in the possession of the state, and are in no way Brady material as defined by the United States Supreme Court. Further, while the prosecution does not have a duty to turn over any statements of the defendant in its possession, such statements cannot be Brady material if they are already known to the defendant. So, for those of you that may not know what a Brady violation disclosure is, it's when the prosecution has some information that would benefit the defendant and they don't reveal it, they don't share it. So something that might exclude them from committing a crime or prove that they didn't commit a crime, or would get them out of the charges, and they keep that buried and suppressed. That when the prosecution does it, this is in basic terms, that's what a Brady violation is. Okay. So, incriminating statements made by the defendant to third parties are not per se Brady material. The state is not in possession of those statements other than what the state disclosed to defense counsel and the court. Further, those statements were not made to a state actor such as the police or the prosecution. This request for Brady violation disclosures shows a misinterpretation of the legal definition and concepts underpinning Brady material. That was kind of a burn, just so you know, towards Mark Means. Based on the rest of the motion, the most charitable burn interpretation of what the declared motion requests is for the state to produce any statements made by Lori Vallow Daybell to Daniel McConkey which are self-incriminating. See Means motion, page 7. The state does not have in its possession or control any such statements. Response to declared motion. Let's see. The state has already disclosed any statements made by Lori Vallow Daybell within its possession or control. Mr. Means can obtain the statements he is referring to by simply asking his client what statement she made. Can we get a burn sound effect? Further, the declared motion makes clear that Mr. McConkey was willing to speak with Mr. Means' co-counsel, Jim Archibald. The information and statements being sought by Mr. Means are simply not within the state's possession and control, and therefore not discoverable through the state. Mr. Means can contact the individuals he claims have the alleged information to gather that information. Nothing about the unvalidated, unsupported assertions have a true connection to the actual application of Brady versus Maryland. The apparent attempt to significantly extend the legal concept of Brady material to cover potentially incriminating statements made by Lori Vallow Daybell to an independent third party and not in possession of the state is supported by the law. I don't know if y'all can hear that downstairs, but my husband is like making soup and apparently got every pan banging down there. Happens every time I try to come up. Somebody does something, so I'm sorry. This is just, I love this filing. I love this response. I love Rachel. I love Rob. Yes, we're on a first name basis. But oh my God, is it pedantic? Pedantic. I mean, it's just like talking down, as they should, because it was a ridiculous, filing. Can you get that stuff on LegalZoom? Because I think you did. The free version. And I'm talking Means. Okay. The public manner in which Mr. Means requests this outline material is concerning, as it appears he intends to publicize statements he believes were made by his client. At this time, the defendant, Lori Vallow Daybell, is deemed by the court incompetent and cannot make an informed consent to her private statements being made public. Yikes. I don't think he thought about that. If Vallow Daybell did indeed make incriminating statements, it is alarming that Mr. Means is objecting to sealing this matter. The potential for harm to Vallow Daybell from publicizing such statements is high and could also be extremely harmful to Mr. Means' former client, Chad Daybell, who is co-defendant and alleged co-conspirator in this matter. It is noteworthy that Vallow Daybell's court-appointed death sentence qualified public defender has not joined in this motion. So basically right here, they're saying you made a big mistake. If you want to publicize this, you're publicizing what your incompetent client said. She's incompetent, so she can't consent to you releasing that information. Oh, and by the way, you didn't really get permission from your boss. It would be Jim Archibald. He didn't sign your paperwork. The declared motion for criminal depositions and out-of-state subpoenas is not supported by law or fact. Idaho Criminal Rule 15 is the sole authority for and governs the taking of depositions in a criminal case. It reads, at any time after the filing of the complaint, indictment, or information, and on notice to all parties, a party may move that a prospective witness be deposed in order to preserve testimony for trial. I don't know why they said italics added, but that's okay. The court may grant the motion if the testimony of the witness is material, and it is necessary to take the deposition of the witness in order to prevent a failure of justice. Rule 15 exists to preserve material testimony, not as a discovery tool. It has long been held in Idaho, and even a cursory review of the case law establishes that Rule 15 exists for situations where a witness will be unavailable for trial. For example, I can't believe they put an example in here. That's okay. Maybe they'll do a puppet show later too. For example, a material witness who has a terminal illness. Oh, Lord. In State versus Filson, the Idaho Supreme Court denied the defendant's motion to depose the victim, stating, from the record before this court, there is no showing whatsoever that the prosecutrix would be unable to attend the trial. Without such a showing, there is no grounds upon which to grant the motion, and the court did not err in refusing to allow it. The declared motion fails to provide any factual basis whatsoever to suggest that any of the individuals listed are witnesses in this case in any capacity. It fails to provide any factual basis as to why any of their testimony would be material and how their depositions would be necessary to prevent a failure of justice. Further, even if any of the individuals or organizations listed were witnesses, the declared motion makes no showing whatsoever of their unavailability for trial. So, I mean, basically what they're saying here is like, you didn't give us a reason why these people are witnesses. Like, why are they important? They don't highlight like what their testimony could provide or how that would be, how it's necessary for Lori to have a fair trial. And it also doesn't state why they can't just be witnesses and why it's basically, this should just read, Dear Mr. Means, you need to go to remedial law school. Thanks. The request in the declared motion for out-of-state subpoenas is procedurally defective. Oh my God. Procedurally defective. A court in Idaho cannot simply grant an out-of-state subpoena. If Mr. Means wants to serve a subpoena in another state, he must first acquire a subpoena signed by the court or the clerk of the court pursuant to ICR 17 and then domesticate said subpoena in whichever state he wishes to have it served. The law and rules in Idaho are clear on the manner in which to obtain process enforceable in other states. The request in the declared motion fails to follow Idaho law and must be denied. So, you know, here's an attorney that's a member of the Bar Association in Idaho. Oh my gosh. Working on Lori Vallow's case. And he doesn't understand the basics of Idaho law. He just doesn't. He just doesn't. And it's so embarrassing to read. I mean, there's so many things going through my mind. Like, I wonder so many things. I'll save it though. I'll save it. But one thing is, if any of this is true, that Lori spoke to outside counsel, I wonder if it was orchestrated from within to get means away from her. I don't know if she didn't have the guts to do it. I don't know if maybe associates, not Archibald, but somebody around there is responsible for making this happen. If it did allegedly happen, I don't know. But clearly Mark means he needs to be one of those fix-it ticket lawyers, because or sit down and learn how to write a thorough motion. It boggles my mind. Number 3, Mr. Means' motion to disqualify the Idaho Department of Health and Welfare is not supported by law or fact. That's a pretty strong statement. So let's just see if they hold this one up too. The declared motion to disqualify the Idaho Department of Health and Welfare, hereinafter IDHW, is baseless and unsupported by the law. Well, there you go. The defendant has been declared incompetent and committed to the custody of IDHW at the request of and on a prior motion of Mr. Means. Incompetency proceedings in a criminal case in Idaho are governed by statutes 18 through 210 through 18-217. IC 18212, parentheses 2 reads, if the court determines that the defendant lacks fitness to proceed, the proceeding against him shall be suspended, which is why her case is stayed, Lori's case, except as provided in subsections 5 and 6 of this section, and the court shall commit him to the custody of the Director of the Department of Health and Welfare for a period not exceeding 90 days for care and treatment at an appropriate facility of the Department of Health and Welfare. Emphasis added. I don't know what that means, but I kind of love it. It's like theater notes. It's just something I'm not familiar with, but just reminds me of reading a script. Care and treatment at an appropriate facility of the Department of Health and Welfare. Emphasis added. The statutes listed above only allow for restoration treatment of the incompetent to be performed by IDWH at ID. They switched at IDHW facilities. That's okay. That's how it's written. Well, IC 18-211, parentheses 10, allows the court to appoint additional experts. That is only in relation to a finding of competence or incompetence. Nothing in the Idaho Code provides for a disqualification of the Department of Health and Welfare, nor does anything in the Idaho Code provide for an alternate method of restoring competence. By law, the court's sole authority to obtain treatment for restoration of the incompetent lies with its power to commit a defendant to the custody of the Director of the Department of Health and Welfare. There is no power of the court to commit a person found unfit to proceed in any other facility. So, I mean, does everybody understand this? This is like, this is where Lori has to go. There's no other place she could go. And the only argument here is whether she's competent or incompetent. And right now, she is incompetent. So I don't know, but right here. By law, the court's sole authority to obtain treatment for restoration of the incompetent lies with its power to commit a defendant to the custody of the director of the Department of Health and Welfare. There is no power of the court to commit a person found unfit to proceed to any other facility. The declared motion's unverified, unsubstantiated assertions fail to state a cause that necessitates the court's intervention in the daily psychiatric, medical, and mental health treatment of a person in the custody of IDHW. Even if true, none of the allegations rise to the level of mistreatment or inappropriate contact on the part of IDHW. Bare assertions, conjecture, and unsubstantiated claims do not support the court taking the drastic and legally questionable action of disqualifying the entire agency charged by Idaho law with Ms. Vallow Daybell's custody and care. The court does not have the authority to micromanage the daily treatment of Ms. Vallow Daybell. The court's concern is with the legal status of a defendant, not on managing complaints about individual staff performance. Should Mr. Means or Ms. Vallow Daybell have a grievance about an individual staff member or members, the grievance process within the individual institution is available to them. Dare I say burn? The court is not part of a facility's grievance process. Grab a comment card, Mark Means. Further, there is no evidence or even assertion in the motion that the facility itself has somehow disqualified itself. The novel argument that the alleged actions of one staff member somehow are imputed to an entire facility and to an entire multi-facility statewide department is without merit or legal authority. So when he's trying to, I mean, I know I don't have to tell you guys this, but I'm talking, to myself too. So when he was disqualified, when he's going for a disqualification of the Idaho Department of, Health and Welfare, he's just writing about the clinician who Lori says told her to call Curtin McConkey and gave her the phone number and made it part of her homework. He failed to give reasons why the entire institution is unfit. But even in that capacity, and even with that reasoning, even if he had written something out, even if he had, Idaho law states that the only place for Lori is there. And, if you have a problem with a facility, like I said, you need to take a comment card, you need to fill it out. It doesn't go through, the judge and the court is not mommy and daddy. You have to go through the proper channels. Clearly, he doesn't understand this. And maybe he does, and maybe he's just crazy. But I think I don't know. I don't know how he got through law school. Honest to God. It's mind-boggling. All right. Beyond the fact that the declared motion's request to disqualify IDHW has no basis in law or fact, even if Mr. Means was able to prove the allegations made against NC, remember those initials NC are for the clinician at the facility. The one that Lori alleges gave her as a homework assignment to contact other counsel and provided her with the phone number to Curtin McConkey and the phone to talk. And then allegedly made it mandatory by making it homework, which was part of her recovery or restoration process. So even if Mr. Means was able to prove the allegations made against NC, disqualifying the entire IDHW would be a drastic and unreasonable remedy. Beyond not providing any actual evidence of his allegations against NC, Mr. Means has not alleged any wrongdoing on the part of the entire IDHW, which would require a disqualification of the entire department. So, I mean, they're saying not only did you you don't have anything to substantiate your, and let's just call it a want. Let's just call it a want. I want. It's so unfair. Mark Means wants the clinician to be, removed, fired, whatever, like all kinds of hullabaloo, all kinds of hearings on this. And he also wants IDHW investigated, but he doesn't provide detailed information or basis or anything like past, nothing. Nothing. It's just basically like, it's a letter to Santa Claus. It's a letter to Santa Claus. So, response to declared motion. Number 4. Mr. Means's unverified, unsupported factual allegations consist of hearsay, highly suspect information, and pure speculation, and cannot be proven without the testimony and cross-examination of Lori Vallow Daybell. And this is beautiful. They call it unverified, unsupported, consisting of hearsay, highly suspect, and pure speculation. It's like we're talking about YouTube. Just kidding. And cannot be proven without the testimony and cross-examination of Lori Daybell. So, hey, we can't even consider this unless you can put your currently incompetent client on the stand to be cross-examined. Nudge, nudge, wink, wink. So that's a problem right there. The declared motion contains several false statements. First, there is no evidence to support the declared motion's assertion that Mr. Wood has ever met, let alone spoken with Daniel McConkey. Another attorney at Curtin McConkey informed Mr. Wood that the defendant had contacted Daniel McConkey. The conversation regarding this issue lasted approximately 1 minute, and Mr. Wood informed said attorney he would notify the defendant's public defender. Mr. Wood immediately contacted the defendant's court-appointed counsel and informed him of the information provided. So that would be Jim Archibald. The state is unaware of any authority creating a duty for attorneys at Curtin McConkey to provide this information to anyone. Further, the state is unaware of any legal or ethical duty that the state had to provide that information to the defense. However, it was provided to both the court and defense counsel as a professional courtesy and out of abundance of caution. So we didn't have to tell you it happened, but we did. And we did as a professional courtesy, and so that you couldn't come running back up here saying, but I didn't get that information. So this, oh my, get ready for a big old burn. Put on your flame retarded suit. Mark Means. The apparent lack of due diligence in filing this motion is egregious and possibly merits sanctions by the court against Mark Means. There we go. Rather than exercise the due diligence required by the rules of professional conduct, Rule 1.3, counsel simply makes speculative and extreme allegations in the declared motion. For example, Mr. Means in footnote 10 appears to claim that the court itself is under the complete control of the LDS Church. Let's take that in. Another example. I mean, I can't, this is like this right here. This is on page 6. When you guys see this, just look on page 6. They lay it out like a 10th grader's 5-paragraph essay, maybe an 8th grader's, maybe a 6th grader's. I don't know, just so Mark Means can read it, apparently, allegedly. Another example is the harsh and unsubstantiated allegations of unethical and possible illegal activities by Mr. McConkey even though Mr. McConkey was willing to and did speak with Jim Archibald. Mr. Means could have simply called Mr. McConkey himself before making such allegations. See Means' motion, page 7. Mr. Means' extreme ethical accusations may have now created a situation where Mr. McConkey is not willing to speak with Mr. Means due to the defamatory statements. So we can go back and look at Means' motion, page 7. But if you recall, Mark Means alleges that McConkey told Lori Vallow he knew who she was, he knew all about her case, and that he made her feel like he was there to help her, and that he led her to believe that there was attorney-client privilege when there wasn't. And that is a huge accusation. Huge. So that's pretty much what we're talking about here. Mr. Means' extreme ethical accusations may have now created a situation where Mr. McConkey is not willing to speak with Mr. Means due to the defamatory statements. So there you go. Mr. McConkey had been willing to speak with the defense counsel, but given the unsubstantiated accusations, may not now be able to do so. The state has no knowledge as to Mr. McConkey's intention, but Mr. Means, by his own actions, may have now limited his ability to obtain the information he is allegedly seeking through the declared motion. So, I mean, he tried to defame McConkey, and where if he had originally gone to him and said, I heard my client called you, like, what did she say? Because I'm still her representation. Can you, download? That might have happened. But now, because Mark Means has made these accusations, and they're very, very serious for legal reasons, they are saying, maybe, but it's probably definitely, McConkey won't speak to Means. And so they further point out that Means is burning his own bridges, basically. There's a whole fire theme here. As further example to the state's knowledge and belief, Mr. Means did not speak with the maligned clinician or her supervisors at IDHW before filing his motion to disqualify. Mr. Means in the motion has crossed the line of zealous advocacy and entered into the arena of rank accusation, made accusations against private individuals, statements about a clinician which could threaten her job, and about an out-of-state attorney who, based on the accusations in the declared motion, did nothing wrong and is now accused of taking actions to manipulate the defendant to be forced to manipulated into making statements against her interests. Mr. Means' representations and allegations about NC, the clinician, and his client are suspect and should be treated as such. At no point does Mr. Means provide a source for this information. As stated above, to the state's knowledge, Mr. Means never spoke with NC about the situation to get her side of the story, nor did he speak with her supervisors at IDHW to ask them to investigate. Unless Mr. Means can produce a witness to verify his story, it is inadmissible hearsay. If the story was provided to Mr. Means by his client, it should be discounted due to the reasons for which he has been committed to IDHW. Burn, baby, burn, Disco Inferno. I mean, it's right there. If the story was provided to Mr. Means by his client, it should be discounted due to the reasons for why she has been committed to IDHW. Further, if the facts alleged by Mr. Means came from his client, he has placed his client in a precarious situation by publishing her statements in violation of her constitutional rights and contrary to Rule 1.6 of the Idaho Rules of Professional Conduct. The state specifically asked the court to take notice that the declared motion was signed by Mr. Means under penalty of perjury. He signed it pursuant to the words that I certify or declare under penalty of perjury pursuant to the law of the state of Idaho that the foregoing is true and correct. There is no requirement he swear to the contents of the motion. He chose to verify the contents of the motion with his name and signature of his own accord, without additional affidavit, witness statements, or documentation. Mr. Means is the sole witness or affiant to the accusations therein. Did I tell you guys this was good? Number 5. Mr. Means' continued representation of the defendant is inappropriate and unethical. Mr. Means has an unwaivable and unethical conflict of interest due to his past dual representation of both Lori Vallow Daybell and her co-conspirator, co-defendant Chad Guy Daybell in regards to the subject matter of this case. Mr. Means' continued involvement, hold on, let me turn off my phone, in this case is inappropriate and creates issues for appeal. An inquiry into this conflict must be held in this case, and a knowing and intelligent waiver of conflict on the part of the defendant must be made in order for Mr. Means to ethically represent Vallow Daybell. However, an inquiry and waiver cannot occur due to the defendant's restoration commitment and related stay of the case. So he's just pissed off the wrong people. Let's be honest. Rob Wood and Rachel have had it. Absolutely had it. So now they're saying, because of this filing, because the accusations made, because of his lack of understanding of the law, that if Means continues on this case, it creates issues for appeal. And they need to hold an inquiry or a hearing presenting this conflict to protect Lori Vallow. And the only person that can really say oh, he really is helping me or I really want him is Lori, but Lori can't make that decision because Lori's incompetent. So, rock, hard place. Further, any waiver, even if knowing and intelligent, any waiver, even if knowing and intelligent, should be rejected by the court. An incompetent defendant should not be presumed to have waived the constitutional right to conflict-free counsel, especially when said counsel appears willing to publicize private statements of the defendant. At a minimum, Mr. Means should be precluded from filing any other documents in this case that are unsigned by his co-counsel until such time as the court can engage in an inquiry with the defendant regarding the conflict of interest. Ooh. So, looks like Mark Means has to have all his work checked, and it's about damn time. He could have had a legal assistant do it, and I don't mean that to demean legal assistants or paralegals, but clearly he needs one. It's like he's going to be back to clerking. And he did this to himself. Conclusion. The declared motions should be denied without hearing as a matter of law. So they're not playing around. They're saying, we don't even need to talk about this because everything here is illegal. I mean, not illegal, but he's not following the law, and he's not filing things the way he should. He's not justifying his filings. It's mayhem. I tell you, the law does not provide the court the authority or jurisdiction to award any remedy requested in the declared motion. Even if the law did allow for such remedies, The declared motion provides no evidence or even allegations which support said remedies. Mr. Means has relied on spurious facts, hearsay, and possible violations of his own client's rights to make the allegations. The state requests that the counsel Means be sanctioned by the court, ordering all motions filed on behalf of the defendant, Lori Vallow Daybell, to be signed by both counsel for the defendant until such time as the defendant is deemed competent, and by any other remedies and sanctions the court deems appropriate. Dated this 24th day of November 2021 by Lindsay Blake and Rob Wood. And was served to Mark Means and filed, served to James Archibald and filed, served to John Pryor and filed, and then Lindsay Blake. Am I saying Rachel? I just had a moment. Hold on, let me look. I was saying Rachel the whole time. It's Lindsay Blake, you guys. I don't know why I'm saying Rachel. I'm thinking of the third. Oh my gosh. The Pro Hack BJ attorney. But this is Lindsay and Rob. I'm on a first name basis. So anyway, sorry I've just been blabbing, but super interesting as far as I'm concerned. This is the first time I'm going to take a look at the chat. I'm going to be way behind, but I'm going to do it. See what you guys are saying. Kathy. Mr. Means, and I say Mr. with all the sarcasm available, has put the final nail in the coffin. Yeah, he has. Definitely. I totally agree. Let's see. I don't know why you guys are talking about fur-lined butt pants, but I'm interested. Let's see. Language of horses. This could get serious. Mark Means needs to go in order to avoid future appeals. Yeah. Oh, okay. Let me read that with the correct inflection. Mark Means needs to go in order to avoid future appeals. Yeah. And it looks like they're going to help expedite that process. That's right. I don't know. Are those punching gloves? Boom, boom. Yeah. Give him a TKO. And that's not a fraternity, Mark Means. Just so you know, it's not a fraternity. Tapakega, ouch. Nope. Let's see. Bethany Boop. Or Bethy Boop? The Bethy Boop. Lori Daybell is incompetent and shouldn't be watching any court proceedings nor discussing the case. Yeah, I'm not a psychologist, psychiatrist, mental health counselor, any of those things. So I don't know exactly what the restoration process is. Maybe there is something to it, like getting her used to it or saying this is happening or this is real. I don't know, but can't say I don't disagree with you. So I'm so far behind. Do you guys have any, let's see, gloves are off. Yeah, I would say gloves are off. Totally. Let's see. Sherry Renslate might have advised Mark Means on the authenticity of said ad. So I'm going to have to look to you responding to Marigold. Now wait, Chris. I don't know what you guys talking about. Hi, Emily. You're not 45 minutes late because I just went on at 5-ish and it was unexpected. I got everything fixed here. I ran home, popped on. I didn't do anything. It's gotten dark since I've been on. So it's all crazy. And there's some delicious smelling soup cooking downstairs and I'm all for it. So I love soup. You guys have any questions? Anything you want me to go back over? Yeah, Angel. I agree. I'm surprised Means is still involved in this too. You know, it's a very, very serious case. There's nothing funny about it. Don't get me wrong when I say this, but in a way, he provided a little levity in the beginning, but now it's just, it's embarrassing, and it's embarrassing to watch. But I'm not even sure Mark Means has the common sense to crawl in a hole and be humiliated by this. I really don't. I mean, they're filing to say that um he can't write anything or do anything without, you know, for lack of a better word, a supervisor signing off on his work. I mean, he's already been demoted, but now it's like, dude, we let you keep the nameplate, we let you keep the office, we let you keep, I mean, he has another office. This is metaphorically. We've let you keep, your office, the manager sticker on your name tag, but now you've gone too far, and so we need the red swing line stapler. You're going to go down to the basement, and pretty soon we're going to take you off the payroll. And you probably know that reference if you've ever seen Office Space. He is late on his TPS reports, and it's all over for him. Oh, can he be removed by the court even if he's on retainer? Well, I think they're going to file a complaint with the bar. And let's talk about, how is he on retainer, Eric? Who's paying for this? Like, where is this money coming from? Where? I mean, any money that Lori would have, I don't know. I don't. That's a whole nother conversation. Tracy Schuler. Hello. The court addressed Mark Means as defense. Are you sure, LD? Yep, I'm sure. Are you really sure? Yep, I'm really sure. Yeah. Totally. I love how they put him in this position. Like, the only person that can really say what happened is Lori. And see, let us explain to you. Lori's incompetent, so we don't believe jack shit. Sorry, excuse my language. We don't believe a darn palabra, darn word that comes out of her mouth. And so unless she's competent and we can cross-examine her, meaning get her up, unless we get her up on the stand, nudge, wouldn't that be fun? Then yeah, that's all invalid. But thanks for trying. I mean, for all we know, Lori Vallow thought she went in and made a phone call, and I don't know. I mean, apparently she did make a phone call. I don't know the circumstances, but he didn't go about getting the answers the right way. He could have gone in and tried to interview MC, the clinician. More than likely, that wouldn't have happened. It would have been escalated, and then an internal investigation would have been done. But he didn't do that. And they had to explain to him in this, like, hey, man, if you want something done in that facility, the court is not going to do it for you. You got to learn the lay of the land. And I'm sorry, I think most lay people know this. So it's really weird. Yeah, I would have thought she was indigent. Now he's hired by the state. You're right. But you're right. Thank you, Kathy, for reminding us. I get caught up in the moment, and yeah, she is indigent. So yeah, they can get him off. They just have to do it the right way. Do it in a way where he can't come back. Do it in a way where when Lori Vallow, if she's ever magically restored, maybe Zalema can use her shield, and one of the other little, maybe Mel Gibb can stir her little pot of herbs and blow on it and think real hard and count to 100, and they can do it. I don't know. Do they like their friend? Apparently they don't anymore. Maybe they made her incompetent. That's what happened. I don't know. But whatever the case, they have to do it in a way where if she's ever restored to competency, she can't come back and say, well, this is why I lost my case, because Mark Means was going to save the day. He's my blue-eyed baby boy, and I need him, gosh darn it. Heck and heck. Does Lori still get $4,000 a month from SSI because of Charles's murder? No. Let's see. Mary Gold says, it is funny. Lori is great at cutting one man from the herd and manipulating them. It's impressive, really. She can spot them a mile away. She can. You're right. She knows. She sizes people up really quickly, and she knows the ones that take a long, let's just use the word grooming, a long grooming period, and she knows the ones that she's like right off the bat, just add water, done and done. Let's see. Okay. Yep. You're right. Let's see. Yes, that's right. Why Lori has been known to manipulate and lie. Yep. It's what she's best at. Well, that and like weird dry rubbing thing in hotel rooms after she's helped weird authors sell books all day. It's gross. Do we know for sure this was homework and not her request for a new lawyer? That's a good question, Rotary Dial, and the answer to that, according to the prosecution, is no. Everything that Mark Means alleges, the prosecution is saying is hearsay, because the only person that can attest to what they said would be Lori Vallow, right? And Lori's incompetent, so she can't say anything. He didn't interview the clinician. He didn't go to Daniel McConkey. He didn't go to Kurt McConkey, the firm. So all he has is basically his crazy client. That's all he has. Let's see. Lori was competent to call the other lawyer. Daniel McConkey? I don't know what other lawyer you're talking about. And they may be teasing, but let's go with that. So the prosecution may be not teasing, but kind of dangling in front of Mark Means like, hey, either your client is competent or, well, they are saying this. Either she's competent or she's not. Like, if you want her to substantiate these things, then she has to be competent to do so, and we have to be able to cross-examine her. And if she called a lawyer, she had to be competent. Mark Means is claiming that she was forced to do this as homework, and she was provided the telephone number and the telephone by the clinician NC, and that is how this phone call transpired. But if Lori can't attest to that and he hasn't interviewed the clinician, then it's just the word of his crazy client. Yeah. So, and she was also competent enough to recall all of this and communicate it with Mark. So I don't know. I mean, I have a theory in my head, and I think I've told you guys this before. Lori, we all know Lori's a master manipulator. And maybe what happened is Lori wanted to talk to another lawyer, and she thought she could call the LDS church or ask for the number for the LDS. I don't know. I don't know how that happened. But when Mark Means kind of heard about it, she was like, oh, crap. And so it was like, oh, they made me do it. They made me. It was my homework. I had to. I'm just this helpless little bunny. I don't know what I'm doing. So Because that's what she does. She tells one person one thing and one person another thing, right? She's always creating these chaotic situations. Let's see. Oh, hi, Anne. Welcome. So glad you're here. Okay, let's see. Rotary dial. Well, how does anyone know if she's represented properly? This needs to be verified by the clinician. Yeah. Well, I agree with you 100%. My sigh is not at you at all. So you know. My sigh is that if you put I think everyone here knows that just a few days later, maybe a week later, just a few days later, John Pryor, who represents No Chin, Todd Daybell, filed something similar. But his motion was very well written. It was more thorough. It was more exacting. Um, so I don't know if Pryor has gone and requested interviews with these people. To be interesting to see how they respond to um, John Pryor's filing. It's any different, but this one, I have to tell you guys, it's a well written response by the prosecution, but it's almost like a parody. It's almost like oh my god, like what I wish I could say. What I wish I could say. You know, I always used to talk about, I'm going to date myself here, but I used to think that it would be wonderful. I remember talking about this with my girlfriends when we were like 16. Like, what if there was a VCR of life? And like, you always have something in your head you want to say to somebody, but you just know that it's wrong, and you go down this road, and it's unkind or whatever. But wouldn't it be great if you had this VCR, you could just do it and then hit rewind and do the right thing, just so you got the satisfaction? It's like Rob and Lindsay got the satisfaction. I mean, it's so conversational. It's almost like it's like a parody almost, although it's correct. And God, I'd be humiliated if I was Mark Baines. But like I said, I'm not even sure he has it in him to be humiliated. I really don't think he does. Let's see. Yes, Lori is the forever victim. And that's why I can see that scenario. Like, I was preyed upon. Like, look at me in here. Yep, Shiva's girl, you're right there with me. Poor Lori, poor me. Poor Lolo. Lolo's loco. Oop, why is that working? Okay. Eric. He somehow got it switched to being listed as lead attorney. Oh my god. I can't. You like my Lori impersonation? I just remember like way, way, way back, like going through Instagram, and I couldn't believe that people actually like her. I don't know if like a lot of you probably know this, but her nickname was Lolo. Lolo. She's such a Lolo. Lolo in her Lululemon, and now she's Loco Lolo in her backless, bony ass hospital gown. Let's see. Aw, Crystal Langford, you're sweet. Thank you. Let's see. Emily, do y'all think anyone else in LDS Church will be held accountable for anything? Probably not, huh? Well, it depends on what you're talking about. I think there's a lot of things that people who are members of the LDS Church could be held accountable for. I'll say that. Oh, Kathy, True Crime Sushi, did I get booted from chatting? It keeps kicking me out. No, absolutely not. No, I don't know why that's happening. I'm sorry. But I have had some little weird gremlins in my channel. I'll tell you that. I will tell you that. No, you guys are so nice. Thank you, Crystal. And Tracy. You guys are sweet. Sweet, sweet, sweet. I don't deserve it. Let's see. Let's see. Put this one up here. Really, they need a new lawyer to prevent any impropriety. It is scary to think she can manipulate everyone, but not have representation smart enough to circumvent this nonsense. Yep, I agree with that one. Leah Vogel, it's because a little birdie slipped these documents to me, and I ran home and literally was home for like 5 minutes and scheduled a live. So it had only been scheduled like 10 minutes. So I'm sorry about that, but I wanted to like get on here and go through this stuff. So I'm sorry about that. Hey, Jesse. It's good to see you. Amy impressions. You guys are funny. Kathy. I don't believe for 1 minute that a professional would jeopardize their state salary by suggesting she call another lawyer. Lori asked for the number on her own. She lies. That is one of my theories. Yeah. I think she just got caught doing her dirty work, and she likes to look good. And so when she was questioned about it, it was like, oh, she was a victim. She was taken advantage of. And, Mark Means will go to bat for her. And all the while it's her manipulation. Manipulation is a lot easier for her when she's free ranging. She's in a mental hospital. It's not so easy. So. Kathy, I can see you. I'm sorry you're getting kicked out of chat. It's weird. I don't even think. Yeah, I don't know. I'm so sorry. You're not blocked or anything, though. I can definitely see you. Oh, IB me, you're going to have to rewatch. Just got here on your list. Well, definitely rewatch. I'm going to post these documents on True Crime Sushi on Facebook, and then I'll put links in other places. Maybe I'll link a Google Doc or something. I don't know, because I know some people don't use Facebook. But basically, the prosecution has responded to Mark Means' filing for Brady violations and all of that stuff for when the alleged Lori was told to call, Curtin McConkey, the LDS legal representation, allegedly, by her clinician named as NC in documents, under the guise of homework. So she was forced to do it. And when she did, when she allegedly did, Mark Means alleges that Daniel McConkey allowed her to think they had attorney-client privilege, and that then he wouldn't tell Mark Means what happened. But he called the prosecution. Now the prosecution knows stuff that he doesn't know, and blah, 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 blah. And I am telling you, this response is 9 pages, but it's very readable. And they make Mark Means so small. It's like, I'm squishing your head, I'm squishing your head, I'm squishing your head. I mean, literally, it could not be more condescending, but in a very deserving way. They schooled him. They took him to school. You have such good comments, Rotary Dial. If Means knew what he was doing, then he would have handled this through the facility and not through the courts. Actually, it's kind of a slap in the face to his making her incompetent. Yeah, absolutely, 100%. I totally agree with you. guys are talking about some riot and barf bags, and I'm here for it. Let's see. Sweet tea. For all we know, the voices in Lori's head could have told her to call the LDS attorney. That's right. That's right. You guys are funny. Lolo, as in Lolo would go that low. Yep. Lolo got low, 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 low. Yep. Ugh. Ugh. I'm way behind in chat. Let's see. This is so 5 minutes ago. Sorry. Picking through the comments. Is Weird Mom in here? You are. Hello. Hey, sister. Soul sister. It's good to see you. I mean that. Let's see. Who filed? Kubi, who filed? Mark Means filed a motion on behalf of Lori Vallow a couple weeks ago. And then the day before Thanksgiving, Lindsay Blake and Rob Wood, prosecution, filed their response. And this is all over that alleged, like, Lori called Kurt McConkie, another attorney. She said she was forced to by her, I keep saying clinician, but whoever's in charge of her care at the facility. And so there were a couple things that Mark wanted. He wanted depositions from all these people, and basically, you know, the state's like, get them yourself, my brother. And he wanted the state of Idaho Department of Welfare, like, and health and welfare disqualified. And it's like, we can't do that. No can do. They're the only, you know, and he want just all this stuff. And then basically you have to read it. I'm going to put these up. But basically at the end of it all, they're like, the only person that can really tell us what's going on is Lori Vallow, and she's incompetent. So unless you can get her competent, we could put her on the stand and cross-examine her, because they'd love to have her bony bottom on the stand. Then our hands are tied, because then it's hearsay. Sorry. Not sorry. So that's kind of how that's going. But definitely read over these, because it's crazy. I mean, it was like the best thing. It was an early Christmas. Really. Early Christmas. Thank you, Easter Bunny. Oh, I be me. You don't like Facebook. It gives you uckies. I know a lot of people are like that. I have to tell you, I'm kind of getting like that myself. So I'll get them somewhere else. Kathy, did you get it figured out? Say it's all good now? Okay. Yeah, Lori Harris. I'm curious about the two. I hope that call was recorded as well. I don't know why he wouldn't go to the facility. I mean, I why wouldn't you go down the proper channels? Why? You just run to the court and think, well, just because I filed this little thing that I learned in my little how-to law book. Oh, horrid. Let's see. Lori might be crazy, but legally incompetent is a very different thing. She's done so many things to show mens rea. I agree. But if she was, I mean, if they depend on this facility or these doctors and agree and all this stuff about the status of her competency, we have to kind of accept that. But I don't think Lori's beneath faking it, and I think she's pretty smart. On the other hand, some days I think you'd have to be a wackadoodle to do some of the stuff that she's doing, and maybe it all set in, but I don't know. Looks like Algo needs a rescue call. Shiva's girl, he's asking. Let's see. You guys are still talking about butt pants, and I don't even know what that is. Yes. yes, she was declared indigent, and so they kept Mark Means, but then they had to get a death penalty certified lawyer for her as a public defender, and that's where Jim Archibald comes in. Yeah. IB me, is that some noise blocking the portal? Yeah, my husband is downstairs rocking the portal. You guys, he found this. So I don't. 2 minutes, 2 minute little story time. So we thought everything, we thought everything was getting back to normal by Thanksgiving, and we had a certain number of people we expected over, and something else happened. And we had decided to go non-traditional this year, so we got blue crabs because we eat turkey, but nobody loves it, and I can't eat half of this stuff, you know. And so we were like, we do crabs and like grilled artichokes because that's like something that I like to make, and I'm pretty good at it. So not like it's that hard, but you know what I mean. So anyway, instead of we're missing like 6 people at Thanksgiving. So instead of having 11 people at Thanksgiving, we had I would say we had 5. Basically, we had 4. So we'd have crabs for 11 people and 4 people to eat them. So Chris and I stayed up, not stayed up, early this morning. We basically picked all these crabs, all the meat out of them. And he's making this crab stew, but he decided he wanted to double the recipe. And so instead of having like 2 pounds of carrots, we have 4 pounds of carrots and 10 pounds of potatoes and you guys, I don't know. I don't even know what's going down there. I imagine it didn't all fit in the pot, and he's like ladling it out into Tupperware containers and like gonna have to cook it in batches, and then it's all gonna be crazy. But I'm just up here doing my true crime thing. So I usually cook in this house. He's a really good cook, but there's way too much stuff to go in one pot. I'm telling you, we're gonna have to open a soup stand. Like, I don't know. Like, come to my channel and I'll give you some free soup somehow. Show it to you. I don't know. Throw it over my shoulder for good luck. I don't know. Hopefully it freezes. Let's see. Anthony Grau. Lori was worried about the LDS Mormon Church removing her like they done Chad. She done it. Yeah, well, es posible, I would say. You guys are talking about Anthony. You're in Facebook jail, little felon. Mm-hmm. Emily said, I would like to know if Chad or Lori's friends believe she's really incompetent. I believe most of them think she's belligerent. But most of her friends are, in my opinion, in trouble themselves and have some deals. So that's just me. They have to be against her. Even if they just, yeah. So just my opinion. Doesn't mean anything. Rotary dial, Lori. Oh, Marky, they make me call another lawyer to give me a new one, but you know I only want you. Mark replies with a face as red as Pryor's. Don't you worry, Angel. I will protect you. Ooh, you need to write a book. I already read it. But you got to draw it like Archie comics. Yeah, Lori, that's what a lot of people are saying. Surely she is, fit to stand trial by now with meds and counseling. But sadly, not yet. Not yet, my pet. Not yet. Let's see. Oh, so when you guys are saying butt pan, it's a joke on bunt pan. Okay, so bunt cakes, butt cakes. Do you remember that? Hey, from Montana. Right here. How are you? It's good to see you. Leah Vogel. Can she get visits at the facility? You know what? I'm not sure about that. I'm sure that is up to whoever supervises her treatment. I don't know. Because she's in their custody now. So, yes, my sweet friend Julian, it is working again. Yay. Yeah, that's right. The swoosh kitchen is open for business. And I will never say no so for you. Yep. All right. Well, I think that's a wrap, guys. I have some other things in the works. I know that Trisha is going on at 10:15. It's a really important night. Please everybody, I'm gonna go grab the link right now. I know that most of you know Trisha Griffith at Web Sleuths, but by chance for my first timers who don't, she's gonna have a really, really good show tonight. And I would love it if you would all head over that way at 10:15 p.m. Eastern Standard Time. And let me just grab that link for you. It's going to be a heavy one, but it's a good one. And it's an important one. So, and of course, it's not letting me share. Give me one second. I'm going to share. I am not going to be selfish. You can't make me not. All right, here we go. Here is the link right here. And I'll type in what's this. Let's get at, oops. Oh my gosh, I can't type. At 10:15, I mean, there's an explanation point in there, but if anybody thinks that it's 101:15, then we got to put you in a little class with Mark Means. I'm going to teach him how to tell time. Oh my gosh, stop saying thank you. Thank you. Thank you, Eric. Thank you, Michelle. Thank you, Shiva's Girl. Thank you, Rotary Dial. Thank you, Michelle R. Thank you, Harley62. Thank you, Kathy, Emily. No, all y'all. Sherry runs late. I'm trying to IB me, Leah Vogel, Language of Horses, Montana Sunset, Kathy M. All you, my sushi crew. It sounds like Gucci Crew all the time I say in my head. And then it makes me think of like songs I wasn't allowed to say way back in the day that I like saying in private. Didn't even get them. But oh well. Marigold! That's right, Marigold. And Algo and Anthony. All my peeps. Crystal. I know I didn't get everybody. Julian, the Weird Mom. XX, Jesse, Diane Riley, and Harley62. All the people are in the house. Makes me happy. I'm glad my YouTube is working because it was driving me crazy. And I don't want to be Lolo Loco. No, I don't. Tracy Howard, Rotary Dial. Kathy. I can't scroll it far enough. I just can't. Scrolling. I think I got everybody. I might not have. And Anne, who's new. My Tracy Schuler. All the good folks. Angel. You see, I know I'm missing people. I'm so sorry. I'm so sorry. The Bethy Boop. Here we go. I think I might have seen Black Lab OG, XX, Shiva's Girl, my other Hey Sister, Soul Sister. G2. Are you feeling fly like a G6? I don't know. That song gets stuck in my head sometimes. Jennifer White. All right, you guys. I'm gonna scroll back down to the bottom. Remember, really check out if you haven't watched Web Sleuths before. Tonight's an important night. It's a turning point for the channel, or not a turning point for the channel. It's an important night for everybody in true crime, and I encourage you to go over there. 10:15 Eastern Standard Time. I put the link in there. I'll put it again. I'll be there. And you know, I mean, if I'm gonna be there, everybody's gotta be there. Hey, Nancy, good to see you. Oh, Mary Jane, you like that song? Feeling fly like a G6. Yep. Means needs to go. Let's get some t-shirts. Go, and I means it. Something like that. Somebody come up with something clever. Maybe we'll have a contest. No, a t-shirt contest. Not a wet t-shirt contest. A logoed thing. Somebody wants to see that going on here. And I'm a married woman. So, all right. On that note, like I say every time, just try and keep you away. Because every time, take care of yourselves, be good people, do good things, follow true crime, support each other. If you need a friend, you can select the record store and Almost Famous. You can always come here, and I look forward to seeing you. And I will be back soonly. Promise by Wednesday, if not tomorrow. Okay, maybe even later tonight. Who knows? I'm crazy like that. Now that this is working, you're not going to keep me off this thing. So, all right, guys. I'll see ya on the flip side.